do more, and become more, you are a leader. It's a beautiful quote quoted by John Quincy Adams. So, with this quote, I would like to begin our talk show named Conversation with Consultants. Good afternoon, everyone. I am Aditi Jain, Strategic Clients Advisor of SK Associates and Group, and your host for today's talk show.
Hello everyone, I'm Shrishti Singh, the head of public relations at SK Associates and Group. It's my pleasure to host this show with Aditi.
Before we begin our talk show, let me briefly introduce SK Associates and Group. We are an ISO certified management consulting firm registered under the MSMED Act 2006 with the Government of India. Our mission is to provide consulting services to student entrepreneurs globally, covering areas such as compliance, operations, marketing, research and development, human capital strategy, and operations. Our passion lies in helping these budding entrepreneurs bring their dreams to life and contribute to global economic growth.
Entrepreneurship is a catalyst for change, innovation. It's a powerful force that can reshape industries, transform lives, and make the world a better place. We are committed to supporting students, entrepreneurs on the journey, equipping them with the tools, knowledge, and network they need to succeed.
Now, before we begin our show, let's take a moment to introduce our guest for today. It gives us immense pleasure to welcome Mr. Amrit Subhadarshi, Assistant Professor at United World School of Law, Karnavati University, to this special event. We are truly honored by your presence today and we are thrilled to have you share this momentous occasion with us.
We welcome you, sir. So let's start this talk show. The first question to you is: what inspired you to pursue a career in law academia, and what led you to your current role as an assistant professor at Karnavati University?
First of all, let me start off this discussion with my warm gratitude greetings to SK Associates and Group for having me here. And to answer your question, well, I would say it was basically a choice of narrowing down your options, trying to figure out what could be the best possible scenario where you don't really know what could be your future course of action. Because just like every other law student, I tried out multiple options, different internships, different courts, and I did come to this realization that probably the corporate field is not really well suited as far as my working needs are concerned. So eventually it comes down to narrowing down and considering that what options you can consider if it's not something that you will engage in on a regular basis. So when I enrolled for my LLM program, my specialization was in corporate laws, and I did my masters from National Law University, Odisha. So there we had an opportunity to basically teach some of the junior semesters who were enrolled in their undergrad programs. And one of the subjects which I was given was on the basics of corporate law. And of course, when it came to presentations and communicating your research to your class, what I understood was I actually enjoy doing that, and my research skills at that time I was honing them pretty well, and I was ensuring that at every step of the way, if I can make sure that the audience to whom I'm communicating my research, if they are understanding and grasping the concept really well, maybe this is something that I can take up full time. And that is when I decided that teaching could be a viable career option for me, and that's how I ended up into teaching. My first experience was at Renaissance Law College Indore, and that really set the ball rolling for a number of other things after that, because you get exposed to a wide variety of students, and not everybody will be as receptive as you think that they might be. So that made me change or work on my teaching strategies, my methods, how to reach to every student concerned. And eventually I've learned that it's a skill, as long as you're able to master it, and you are able to communicate your research well to your audience, people will see value in what you are saying.
Thank you so much, sir, for sharing the insights.
Yes, thank you.
So, can you share some highlights or memorable moments from your journey in legal academia thus far?
Well, when I started out first, I'll be very honest, it was not something which I had as a first option in my mind, because just like everybody else, in law school, when you are tempted to think that you might join practice at some point of time. But what I figured out eventually was that if you want your creative pursuits to be well represented on a larger scale, if you want your audience to connect with you at a level where you know that the research that you are doing could be extremely fruitful for different categories of students, so that made me decide that okay, this is the profession that I would opt for. And also, along that journey, different aspects of teaching profession I noticed. So one instance was like most recently, I was in Thailand for an international conference, and I presented a paper on digital markets and competition law. So there, I was awarded the best researcher in the legal studies category, and I got to network with a wide range of professionals, ranging from, of course, the native country itself, but also from different other participants. So we had basically participants all the way from Vietnam, a couple of them from Europe. So when they actually get to see your research and how you are implementing it at your own level, they connect with you more, as opposed to simply networking with them on different platforms. So that is something which I find an interesting thing as far as the teaching profession is concerned, because you get to show your creativity at will, and not get bogged down into administrative efficiencies every now and then. So for me, that has been one of the main highlights in my profession. And also, occasionally, when I would say when you are doing well in your research and people are reading about it, it always helps that different institutions will try to add value to your research, and so they could extend some collaborative interests or some sort of pursuits where they see a future potential. So these things would be a highlight as far as the profession is concerned.
Thank you for highlighting it.
So, what are your specific areas of law where you are most passionate about, and how do you incorporate those interests into your teaching and research?
Well, corporate law has always interested me from the very beginning, but I guess this statement would have been true if it were made 5 to 10 years before. Now we are living in an era of maybe what I would suggest as digital renaissance. Borrowing a term from one of the my favorite authors who I read on this is Dan Coe. He's a authority on this subject. Um, but more to the point, the reason I mentioned this is because we are seeing that corporate law is slowly getting integrated with technology, and there are everyday instances of this coming up. For instance, most recently, we have read news reports that how the company OpenAI, the developer behind ChatGPT, is being sued by Elon Musk on the grounds that they have breached a contract. To make The contract was originally regarding to keep OpenAI for public access, but now with the help of Microsoft, they are trying to monopolize it. So corporate law every now and then keeps on interacting with digital technologies, and when we look at my field, which is competition laws, there is a huge jurisprudence which is emerging on how these big technology platforms like Meta, Apple, Microsoft, Alphabet, for that matter, how are they abusing their dominance in the digital markets, and that is also my area of specialization. So more specifically, I would say that these are some of the areas which are growing and would be more relevant. So anything which is related with technology and its integration with corporate laws, that always fascinates me. And that's why I keep on reading on this, I keep doing research on this, because one thing is for sure, whether we like it or not, technology is going to play a huge part in the legal profession. And not just the profession, even the academics part. Like for example, if we see how artificial intelligence has played a role, for instance, most recently in the last semester, I taught a paper on AI and cyber laws. So that was a paper which focused exclusively on how AI can impact different aspects of cyber law. And there we discussed different areas where education can be impacted, and also how legal practice can be impacted. So all these things, all the fourth industrial revolution concepts, whether we talk of blockchain, AI, internet of things, they are slowly getting integrated with different facets of corporate law. And it is very important that somebody has to carve out a niche in these areas, because this is one area which is going to remain dominant for a long period of time. So there needs to be some order and some sort of strategy how to figure out a way to understand these concepts in the context of legal developments. So technology and corporate law therefore is my chosen area.
Thank you so much, sir, for sharing.
Yeah.
So, how do you balance your responsibilities as a teacher, researcher, and potentially a practitioner or consultant outside of academia?
Well, to answer that question, I'll just take a slight digression. There is this book that I've been reading very recently. The name of the book is called Hyper Focus. So this author, Chris Bailey, he comes up with a concept called attention management. So why am I saying this? Because for most of us, we have been very confidently laid to believe into the idea of time management, and which is true. I mean, it's not completely false that you have to have the necessary skills for time management. But in that book, Chris talks about this new concept of attention management, where he basically argues that you have to give enough uh, attention to the tasks at hand as opposed to allocating time for that. And when I think in hindsight about how I managed, to be honest, it's not a real foolproof plan that I have, because it keeps on changing depending on the circumstances and the needs at hand. But of course, a basic routine will go a long way in helping the stage. So what I do is, for, let's say, the next week, the classes which I'm supposed to take and the initiatives which I'm supposed to take, I carve out time in during the day after my classes to allot some dedicated time for preparation for the upcoming classes. And research is one thing which goes on constantly, even during weekends, because presently, since I'm pursuing my PhD, so that's a big compulsion to pursue my research. But even otherwise, there are so many avenues which are open. And it always helps that whatever you are researching on is the same thing you are teaching, because then you don't have to do the double work of getting into different activities separately. So for me, I consider myself fortunate in that regard, because I'm also teaching competition law presently, and I'm also doing research in that area because of my PhD work. So both of them are coinciding in that way. And the basic routine I follow is that for every day, what classes I prepare for it in the evenings, and for my research work, I carve out the time, some time from weekends, of course, because you need a little bit of time to yourself as well. But of some selected time for your research activities, so that everything is on track. And most importantly, when I read up on a diverse area of subjects, so because when I talk about my subject, it is not just the law part, it also includes things like technology, economics, basics of how these things are interacting. So I try to read as much as I can, especially newsletters, different categories of newsletters. I maintain a routine in that regard. So I make it a point to read as many newsletters I can, so that they can give me research and teaching insights, which I can incorporate into my class network. So I think that system works best for me. Of course, there cannot be one uniform system for everybody, but I think this is something that works really well for me.
Thank you for sharing. Very well said. Thank you.
So, what advice would you give to the students considering a career in law academia? And what skills or experience do you believe are essentials to succeed in this field?
I think one of the first skills that one would require as a lawyer will be to, as sorry, not as a lawyer, as somebody who wants to teach the practice of law. One thing which comes to mind is the ability of communication. A lot of times people will say, or maybe even think, that that's an easy job, because a lot of times we take these things for granted. But having been in this profession for about 6 years, I know it's quite the opposite. Because what happens is that you might think that you know a lot on a subject, and the real skill is not the knowledge part, it's communicating that knowledge. And that is where I see a lot of times mistakes can happen, because you might try to convince an audience to the best of your ability and to the best of your intention, but you really have to get down to their level of understanding and not speak in superfluous terms. So for example, when I teach competition laws, what I try to do is, I try to take up everyday instances from newspaper reports or anything, and try to make a hypothetical situation out of it to which they can relate. And then using that, I try to imbibe concepts into their minds, which I feel that they learn from it much more strongly, as opposed to just theoretical academic discussions. So that is one skill which I believe anybody who wants to take up a career in academia needs to have. Of course, that goes without saying that research, and that to constant research, is something which one needs to do. But what I feel is that along with research, you need to ensure as an academic that your research is disseminated as well. It's not enough if you just simply publish and then move on to the next one. um, it also has to be about a wide range of people reading your work, because that's how you familiarize yourself with people from your community. Otherwise, even if you have published 50 to 100 papers, and if nobody's there to read it, that could be in my opinion, a tragedy for an academic, because even if you've given all the effort, nobody really knows your work. So that is another skill, the ability to disseminate your research. And lastly, I would say, even if there is a lot of pressure on many young academics, especially to qualify their NET exams or to go for PhD, of course, those are important things that you have to do. But one must also have this ability to differentiate that that is not the end in itself. So for example, if I'm doing my PhD work and I complete my thesis and I submit it, my next goal should not be to see the end of it. It should be how to create more opportunities from within that PhD thesis, carve out as much research papers as I can, network based on those research papers, and really create something which nobody else has done before. Because those days of academics just going to class, teaching, and talking about your research, those are long gone. Now we have to think, how can we make our research count? How can we ensure that whenever we are talking about different aspects of our research, what value addition are we doing it for students? Because students these days really dig up a lot when it comes to their professors. It's not like how it used to be, whatever the teacher used to say will always be the gospel truth. So they would want to know what it is you are saying and how it is adding value for them. So I think something original from that research, which can show them that it makes them employable, that is also the job an academic should have. So yeah, these are the skills which I feel are important. I know that there is not one golden rule for this, but I believe this sort of a strategy helps me a lot.
Thank you so much, sir, for sharing the insights.
Thank you.
So, how do you stay updated with current legal developments and trends in your areas of expertise?
Well, so I think one of the first things what I do is I identify resources. what are my resources going to be, because as you are very well aware, we live in an era where there is an information overload, and you have to classify the information, what you consume and what you don't. So as an academic, it goes without saying, books and journals are your bible in that regard, so you have to read them. But books and journals are merely sources of information which can become outdated very quickly. So and this is something which I regularly advise my students also, that if you want to remain updated in your area of law, even if you are not a habitual reader, because not every student will be, at least you need to carve out time, some time from within the week, to read whatever interests you. It doesn't necessarily have to be the area of law that I'm talking about. It could be anything. It could be constitutional law, it could be environmental laws, but you need to be very sure of what are the resources exactly that you want to follow. And then once you have identified those resources, you need to have a plan how to read them on a frequent basis. And reading, I by reading, I don't just mean sitting with a book or opening a website or a blog or an app and reading it like that. What I mean is really sitting down and making a flow chart of some sort, or a mind map or a vision board of some sort, which helps you retain that information more. So what I do is I have a list of resources that comprises of blogs, newsletters, different books on my area. But I also know that my area concerns with different disciplines as well. So for example, competition law interacts a lot with economics, general corporate practices, so I need to be updated with work from that area as well. So if I'm teaching a class on competition law, I won't just teach on the legal aspect. I have to tell the class what was Adam Smith's theory all about, why is Adam Smith so important for competition economics in general, so that the students can really get the philosophy of the law and not just the dead letter of the law. So what I mean by that is, if you are trying to be very cautious in your approach and very sort of having a tunnel vision about what you want to teach, then it won't help you in the long run as an academic, because you have to widen your options, and you have to make sure that the sources that you have identified, whether they are newspapers, they are blogs, they are newsletters, and constantly draw connections between all these sources. So, for example, if I am reading a blog on how the Competition Commission of India gave a judgment on the famous Play Store case, it won't be enough if I just read the blog. I will also have to track down the original judgment from the CCI website, read up a few articles, scholarly articles on the same area which others might have spoken of, read opinions of scholars who have supported the judgment and those who are against the judgment. So the knowledge of not just the resources but how to use those resources is a skill that I think all academics should learn, because that way you are cutting down on a lot of time which you can otherwise waste, and you are basically creating a model for yourself where you are trying to read smartly instead of everything that comes at you, because our attention spans are reducing day by day. So it always helps if you have a plan how to use those resources smartly in your favor.
Exactly, very well said. Thank you.
Thank you.
Sir, can you discuss any ongoing research projects or publications you're working on and what impact you hope they will have on the legal community?
Well, apart from my PhD thesis, which is on digital platform markets, the big technology platform markets and competition law, that is, of course, that goes without saying that that is one big research project. It will absolutely go on even after my PhD gets completed. But there are plenty of other options which I'm looking forward to start with. For example, we talk of artificial intelligence and how these big technology companies and most recently when we see these legal battles going on between OpenAI and Elon Musk. Elon Musk has his own AI company, which is apparently a big competitor to OpenAI, the creator of ChatGPT. So the intersections between AI and technology competition laws. There is also something big area coming up when it comes to the usage of internet. So those are the things and their intersections with competition laws. How maybe the regulators, both in India and in different jurisdictions, they are grasping to these realities, because when we speak about the implementation of these kinds of laws, there is something known as a technology law conundrum. The idea of it is that technology will always remain 10 steps ahead of the law. So it is the legal system's job to play catch up and not otherwise. Therefore, one has to always make sure that whatever research you are doing, it has to be interdisciplinary in nature, because no matter what area of law you're dealing with, the days of only considering the law in question, that is over. Because when I talk about something specific as Web3, metaverse, AI, and their intersections with legal developments, then we'll see that there is no uniform format, or any regulator for that matter of any country has not specified how do we regulate these technologies. I'll give you an example. A few months before, there was a court in China which basically debated on the question that if artificial intelligence could write a book, should it be granted authorship under copyright laws or not? Now, these are the kind of questions that we have not faced as a legal community. And when I say we, I don't just mean us as the Indians legal system, but generally. So therefore, these are the kind of things that I believe, as an academic, if you want to focus your attention on, you will never run out of options for doing research. Because the one thing which is very clear, and from what I understood in my experience, is that if you keep on doing research in these things, then there is no set limit at which you can point out and say, okay, yes, I have done enough, because it will never be enough. So as opposed to other conventional areas of law. For example, if somebody does a research on constitutional law, purely constitutional law, or purely taxation law, so a lot of literature has already been published in many aspects of that. Now, the real challenge is to ask as an academic, what new innovation or what new things am I adding into this debate? That is where people will step up and recognize your potential as an academic. For example, if I simply write on what is abuse of dominance, it won't be of much use to me and for my community, because people already know what it is and they have read enough on it. But if at the same time, if I can manage somehow to relate it with the emerging technologies, that will show people value that, okay, yes, there is potential here as well. So therefore, most of my research papers which have been published has been on technology and the law part, because I believe that it's an evolving area and there is no saturation point when it comes to these emerging technologies. All you have to do is look for trends, and if possible, set the trend yourself so that others can follow. So that's what I aim to do.
Thank you so much, sir, for sharing.
Thank you.
How do you approach creating a supportive and inclusive learning environment for your students, particularly in topics that may be challenging?
Well, when it comes to students, before you delve into any topic, what really helps is if you understand the demographic pretty quickly. So, in a class of, let's say, approximately 50 students, you will have 10 to 20% students who are above average. Majority will be in the average category. And when I say above average and average, the parameters of it will also keep shifting based on the subject that you are teaching. A lot of times, students have these preconceived notions that a certain area of law is pretty boring and a certain area of law is very interesting. I keep getting those remarks even till now. For example, when somebody will say, okay, constitutional law is boring, but company law is very good, and occasionally vice versa as well. But what I feel, and this is what I try to do in as far as my classes are concerned. I'm not sure if this is the only technique or a uniform technique, but I believe you cannot have one, because every teacher is supposed to be teaching in a different way and students are supposed to understand the best way possible. So what I try to do is I try to make it into a fun and enjoyable game. What I do is we do a lot of role play activities, a lot of role play exercises, where students can be able to relate to their characters much better. And also it helps because we have to understand that students these days are not having that much retention and attention capacity. So you need to be able to show to them that what you are doing is meaningful for them. What I think is that the only way they can understand it is you have to go beyond lectures. You have to really involve them as part of the decision making process. So what I do is I set up role play activities, simulation exercises, assign roles to different students for the role play, and then I throw in an idea and I encourage the students to discuss opposite sides of it. But that way, when I see them that they're engaging in something more, in a very how should I say, put it, in a manner which is much more fruitful for them, they themselves want to be a part of it, as opposed to me saying them that you need to be a part of it. So I think that helps students a lot, inclusive, and it's of course inclusive because they will see that when some of them remain outside of the class discussion, they start to have that need, that they feel the compulsion that okay, fine, I also want to contribute something, I should not remain quiet. It automatically encourages others to also pitch in and say things which are relevant for the discussion. And occasionally what I do is and this is something which I've tried very recently. So I've observed a trend that you cannot just expect students these days to, read newspapers even 2 days a week. That trend has long gone. So what I try to do is basically anything which is of relevance from my area, and if I'm teaching on it, I make it a point that at at the end of every class, or maybe 5 to 10 minutes before the class, we have a short activity where that day's particular news which is relevant for my chosen topic, whatever I'm teaching, and I make the students read that article and then ask them to apply the concepts that we have discussed in class, the previous class. So that way they can see a real world application to things that are actually existing, as opposed to discussing abstract concepts which they will forget after the class gets over. So I believe that is one way to increase retention capacity and make it much more inclusive. So that's what I aim to do.
Thank you for sharing it.
Yeah,
इनको आवाज कम कर यार.
I think the microphone is muted.
Srishti, you are on mute. Yeah.
Sorry.
No problem.
Sir, what do you see as the biggest challenge facing legal education today, and how do you think they can be addressed?
One thing which I observed as far as legal education is concerned is that a lot of times when we are divulging so much of content into students, they, even if you do it to the best of your intention, there comes a time where you feel that there is a gap in what you are saying and how much are they actually retaining. Because from a student perspective, what they are thinking is basically how to finish up the subject quickly, what are the important reading materials that can be assigned for the next upcoming exams. Because let's be honest, when at a student level, very few students will actually think long term, okay, this is something useful or interesting. Most of them will be more likely to be inclined for examinations and those kind of things. So I believe one of the biggest challenges is that getting everybody on board with your idea is tough, especially now when students have so many options. For example, if somebody is teaching a contract drafting course at their institution, students do not necessarily feel the compulsion. that they would like to attend this class because they have online courses at their disposal, so they can easily enroll for one and get themselves acclimatized to how it works. So what I feel is that the industry academia connect is something which is still missing in many institutions, and I believe it requires a collaborative effort on both the sides to take up that, because um, increasingly students will want to know, especially if you are a student who is interested in corporate law, you will want to know how transactions like mergers and acquisitions look like in real life. So for example, if I'm teaching a class on the most recent transaction between Reliance and Disney, it will not be enough to tell them about the facts and how that transaction materialized. It's also advisable that they know how they negotiated those contracts, what were the clauses they included, what parameters they decided on which they would include those clauses. Now, this is something an academic won't be able to do, because let's face it, as an academic, you're not trained for that. For that, you need industry practitioners, professionals who will be able to deliver the job much better. But having said that, academics can add value to the theoretical conceptual understanding that the students can develop. So one of the challenges which I feel is that there is still somewhere a gap between the industry and academics as far as legal education is concerned. um, and so therefore, as much as possible, these things should be emphasized on. One other thing which I find it pretty challenging these days is the time of reading good materials, whether it is books or journal articles or even simple blogs on different forums. Students are not reading anymore. They would be more happy to read from infographics, flashcards, anything which is under a minute. That is one thing which I believe it's challenging, because yes, the legal profession encourages brevity, but at the same time, the essence of education is that you should be having an inquisitive bent of mind to keep learning as much as possible, and that is an interest which I see declining these days. So teachers have to be much more innovative in what they are, the kind of content that they are delivering, because the days of the teachers going to the class and giving out information, that's just not going to help anymore. So for example, what I try to do is, I try to ensure that the activities which we conduct in class, so we have a system where we are trying to constantly rate and rank students based on how they are performing in these activities. That keeps them incentivized to do well and to do better, or at least try to do better. At least they are taking some sort of practical learning away from the class as opposed to purely conceptual discussion. So that is something which I feel there is a challenge. And lastly, I also think that the emphasis on technology law is not very good right now in many institutions. Technology law is a big field which is coming up for legal practitioners. There is a whole new area called legal tech, very common in the Western countries, some of the Middle East countries also. But when it comes to India, it's largely limited to law firms, and that to a few tier one law firms. Not every law firm is experimenting with these kind of new technologies. But students need to have a course where technology law is implemented as a mandatory subject in different law schools, because we need to be able to make our students employable. And technology law, I think, will be a huge factor in that. So I think if these challenges are issued, it could go a long way in in mitigating the losses that we are currently having.
Thank you so much, sir, for sharing.
Thank you.
Can you share your perspective on the role of technology in legal education and the practice of law and how it is shaping the future of both?
I'm sorry, there was an audio disconnect. Could you repeat once more?
Sure, sure. So, can you share your perspective on the role of technology in legal education and the practice of law and how it is shaping the future of both?
Right. So when we say technology, we have to go back a few years before. The interpretation of the word technology, at least a decade before, was understood to be, ability to use Microsoft Word, MS Excel. And of course we know very well that that time has long gone. Now when we speak of technology, we are the one thing which immediately comes to mind is how do we use AI, because it's the most dominant kind of technological work that we are seeing that is slowly getting integrated into legal practice. I'll share one of my examples, what I did with my previous class in my last semester. So, when I was teaching them how AI can be used for contract drafting, I, of course, did a lot of research in that. And I came across this Google Chrome extension called Better Legal AI. So what it does is basically if you install it as an extension on your Google Chrome browser and you feed it contracts, it will try to give you analysis from both the parties who are about to enter into a contract. So what I made my class do was I made them download a non-disclosure agreement of any two parties, and then I made them install this on their browser, and I asked them that with the help of this AI tool, figure out a way to determine potential areas of concern for both the parties who are about to enter into this agreement. And the students took it very exciting manner, because they don't have to go and delve into hundreds of clauses manually. And you know how a lot of times when law firms engage in these kind of activities, what they do is they the traditional ways, they keep the MS Word switched on to the tracking mode so that they can track whatever changes they are doing. But now law firms are increasingly using legal tech such as AI and other emerging technologies to create not just contracts but to also create due diligence rooms, to create repositories, databases, and reducing their time. So that is a skill which I think that students need to develop in the law school itself, because we can't keep on teaching them outdated skills if they are no longer relevant. So I felt that in that course this is one activity where students were very interested to take up. Also, couple of students have approached me before regarding how you can write research papers on technology and law, and I'm working on a few as well with some of my students. So for example, how superhuman artificial intelligence could help the legal profession. Is there any scope for using blockchain in the legal practice? And if there is, how useful are smart contracts? So I think these things need to be part of the regular course curriculum in law schools. And if it happens, then I believe students will have a renewed interest as opposed to reading conventional subjects, and maybe they can figure out a way to find a nexus between the conventional subjects and these emerging areas. So I think, yeah, that's one strategy to go.
Very well said. Thank you for sharing it.
Thank you.
So your journey from being a legal analyst in Brussels to be an assistant professor specializing in competition law in India is quite remarkable. Can you share the some moments that led you to transition from practice to academia?
As a legal analyst, my job, so I was basically working in the IPR team of my company. So we had just one job, to analyze trademarks from different companies outside of, from the European Union. So because the head office of this company is located in Brussels in the EU, so our job was basically that if any of those companies wanted to set up offices in India, they would send us their respective requests to ask for protections under Indian trademark law for whatever images or any kind of pictures or any logo that they're trying to protect. Our job was basically to do a thorough review of that and to recommend through our offices back to their jurisdiction whether they need to alter their application or some any sort of documents and maneuvers that they need to do. And yes, it was interesting, but at the same time I still developed an interest, like I said, after my LLM, for research activities, for communicating that research, and that could not have happened if I would continue as a consultant. Yes, it did provide me with valuable practical insights into how the consultancy world works, but at the end of the day, I still feel that making that transition was a big jump for me, because I always felt that if you possess that ability to communicate well, and if you have that ability to do quick research and engage in creative work which does not look at merely the office times and everything, then teaching will be the right profession. So that is why I decided to make the career switch. And then I started working on my areas of interest, things which really appealed to me, like it could be mergers acquisitions, it could be competition laws, and how they are relevant for as an academic, how it is relevant for you as a student as well. So I realized that you can only do it full time and not part time if you're working as a consultant, because when you start working at an organization like that, uh, this is something which will take up a lot of your time. It will not really free you up, and whatever time you have left, you would be rather spending it on yourself than doing research. Now I didn't want to do that. I wanted a change of circumstances, because I wanted to do full time research and not something in a half-hearted way. So I believe that decision started my journey from analyst to academic, and I'm I'm still continuing with that, and I'm making good returns out of it.
Thank you so much, sir, for sharing.
Thank you.
As a specialist in competition law, your recent webinar on metaverse and competition law caught our attention. So, could you elaborate on the intersection between emerging technologies and competition regulations and how it influences your research?
Right. So, for that, let me just give a brief context into what metaverse is, and in why is it suddenly becoming so relevant for competition laws. That's only because we are now at a time where you can easily say that we have entered into an era where the internet has become much more active, in the sense that when the usage of internet started, if you go back to the 1950s and 60s, when it was only used for military purpose, we have come a long way since that. And people and enterprises both are looking to seek much more value from the internet as opposed to just what we are seeking right now. So that is where the third generation of the internet has come up, and there is this growing idea that all these big technology platforms that we see and we use on a regular basis, whether it is Facebook, Google, Microsoft, Apple, because of the amount of the volume of data that they possess, they are in a very advantageous position to misuse it as well. It's a lot of incentive for them, and we see many cases have been filed against these big technology companies, not just in India but across many jurisdictions like the EU and the US also, for that matter. So the bottom line for what these cases is that they are using the data power which they have to leverage their dominance in markets and influencing customer behavior. So Web3 tries to change that, and Metaverse is basically an application of Web3. So the idea is that think about it like what happened in the 2008 financial crisis. People lost faith in the banking system, right? And then came the idea of bitcoins, that we do not need banks and financial institutions, we can simply transact peer to peer. So Web3 tries to address the same problem by stating that if the users of the internet have more control over whatever information they are feeding and consuming, as opposed to the big technology companies, then that will give more autonomy to the users and less incentive to the big tech companies to manipulate our preference and choices. Like one example I'll give you. What recently there was this news where many e-commerce companies are utilizing algorithms to engage in what is known as dark pattern behavior. So we are basically being forced or nudged slightly to, or even you can say manipulated to, prefer some certain products over certain others. So Web3 and Metaverse tries to do away with all that. But then, if that happens, this is a bad thing for those companies because they are suddenly losing control, and you're giving away control to, all your consumers. So that is why this area of research appeals to me, because it's trying to bring a paradigm shift, something which has not yet been done before. And it will try to set a precedent which is pretty remarkable, if you see, because so far we have been taught that companies and enterprises will try to abuse their dominance, and it is the law's job, the legal system's job, to prevent that from happening. But for the first time in recent history, we are trying to come up with a technological solution and not a legal solution. Of course, the legal solution will always remain, but we are looking at it from a different angle. And maybe that is something which can try to revolutionize the internet. So I believe that's why this area of research is very interesting to me. And the concepts, fundamental concepts of competition law and how it applies to this area will never change. For example, we know that the platform Facebook is being run by Meta, and Meta at any point of time, or like just like how it had happened in the Google Play Store case, Google compelled the app developers that you have to pay us fees or you can't remain in the app. And the competition commission intervened and said you can't do that, it's anti-competitive. So the fundamentals of competition law will not change, but the evolving technologies around it, those are fascinating. And my observation is that this paradigm is never going to remain constant. What remains relevant today can instantly become irrelevant tomorrow. So that is why this area appeals to me and is of interest to me.
Thank you for highlighting such facts on it. Thank you.
Thank you.
So, being the first author of the book on standard essentials of patent and abuse and dominance in the global telecommunication industry is a significant achievement. What inspired you to delve into this particular aspect, and what keys insight do you believe professionals in this industry should be aware of?
Yes. So that book was basically, at that time, intellectual property and smartphone chipsets were a big deal. Just like now, when we are talking about digital platforms, that book was published in 2018. It's not that old, of course, but times have changed dramatically since then. So when I was doing research on that book, there was a lot of global litigation going on around how these chip manufacturing companies, those chipsets which we use in our smartphones, so these companies, they get a lot of patents on one single chipset, and then they use that patent to extract exorbitant royalties from the handset manufacturers or the device manufacturers. It's a classic example of how intellectual property is being misused to perpetuate abuse of dominance. And if you read upon it, you'll find that there are plenty of cases which have happened, both in the Competition Commission of India as well as in many jurisdictions. You can take US, Japan, China, European Union for that matter. A lot of research has been done on this. And my interest to work on this area was, it was one of the very first interactions, significant interactions of me with regards to technology and competition law. So if I am choosing tech and competition law, the ambit cannot be a narrow one, it has to be a wide one. So that's why I took up IPR, and presently I'm working digital technologies and competition. But the fundamentals of that umbrella term of tech and competition law, that has not changed. So what I found was that there is very rare jurisprudence on IPR and competition law when it comes to the telecommunication industry, especially if you look at the smartphone chipsets. Now, that is a very niche area to work on, and competition law always works if you have identified a very niche area. It will never work if you say, okay, fine, okay, this company is in this sector, and this is how we are going to approach it. You need to first understand what the industry is, what the market requirements are, how many companies are there, what kind of contracts they enter into, and then you figure out a way to include law in that process. So business has to come first, law has to come secondary. That is why I took up that area, and I saw that in that particular area a lot of literature has not been completely done. The review of literature which I did, I found that many scholars are also working on the same thing, but there is no uniformity in that area, because even now that area is still evolving. So that was my first attempt to basically disseminate my research to as much wide audience as possible, to show that there is a viable opportunity even in tech and law as far as the research is concerned.
Thank you so much, sir, for sharing.
Thank you.
Your commitment in making teaching interesting and innovative is commendable. So, how do you incorporate real world examples or recent cases into your classes to engage students and make complex legal concepts more accessible?
So I'll share with you one example what I did very recently. um, Most frequently what I do is I pick up articles from two newspapers. They would either be Economic Times or Business Standard, because I like to read both of them. So at a given point of time, if any topic has been discussed in detail in any one of the newspapers, I just pick out that relevant section which I feel the students will be able to best relate. And after teaching a subject for a while, knowing to understand your students at that level, you develop a fair sense of idea who is understanding at what depth. So I pick a topic which at the back of my mind I know will seem very interesting. For example, I know for a fact that anything to do with OTT, or anything to do with Google, Alphabet, Meta, these things immediately catch the attention of the students. You won't even have to do much of an effort to get their attention on that. So I try to find out topics which are basically centered around those themes, and then try to see whether the application of competition law is something which the students are able to find or not. Because it should be a class where you encourage students to use their creativity, to use their imagination, and to come up with answers. They should be the one to arrive, and not just arrive at an answer, but arrive at a methodology of how they found out the answer. So what I do is I pick up these articles, I explain the concept, we do some activities, and at the end of the class, maybe a few minutes before the class, I schedule the last 5 to 10 minutes of my class for activities like this, where I show them that article. I ask them to read it first, and then tell me how do they think the concepts that we are reading or discussing are relevant for them in the context of that article. And I make it a point to tell them that your answers should be basically, few answers should be pro and few answers should be anti. And that's why, so that we can have a basic discussion, and I make it very clear from the start that there is no one right answer. Because a lot of times students will have this
और
apprehension
बताइए
that what if I don't say it correctly.
रिकॉर्डिंग करनी है
So I try to say it very clearly that you don't
और
have
कौन
to
जा रहा
have
है
one right answer, because you cannot. It largely depends on your interpretation and reasoning. And students find it interesting because anything related to tech, they really, even if they don't understand it fully, but still, because they're involved on an everyday basis, they relate it with in a more meaningful way,
5 मिनट
as opposed to discussing just a case or another case study. So I think that is one way I approach with this methodology.
Thank you for sharing this.
Thank you.
I would like to ask anyone have any questions could raise their hands. Anyone have any questions could raise their hand, please.
I think we have one question.
Yes, Mr. Narendra, please, you can ask the question.
Sir, I I completed my MBA sir last year sir. I sir want to enter into the legal industry sir, but sir I have not completed LLB or LLM sir. So is there any particular path forward for me sir? How I can enter into this domain sir?
You wanted to enter into the legal practice profession, if I'm not wrong.
Yes sir, I'm interested in this sir.
Right. So, of course, entering into the legal profession can be through multiple ways. There used to be this thing that you can be an advocate only, but of course, those things are gone now. You can be a consultant. You can work in any of the or I was a consultant, part analyst as well. But if you are looking for practicing, then the basic thing that you have to opt for is you need to have your LLB degree to be completed from a BCI Bar Council of India recognized university, and you need to enroll yourself as an advocate. That is, if you are looking to practice. So, presently we have the All India Bar Examination, the AIBE. So, if you clear that, you can practice at any court of law in India. But if you're looking to practice in a particular state, then even state bar council's application you can fill out, but that can only happen if and when you have completed your LLB degree. So my suggestion is following that path, and then the road is clear for entering into the profession.
And sir, kindly let me know regarding the consultant also sir in detail.
So basically, the consultant's job is to review documents, do a lot of research, give advisories to your clients. Like what I used to do was, so I did not practice. I did not have any interest to practice law, but I found consultancy to be interesting. So I took up that, and the what you'll do is basically you will be interfacing with clients a lot. So if you are well versed with your area of law, you can advise them on the present legal situation of any particular issue which they have raised. You can also draft and assist them in research with whatever documents they are saying. You can engage in licensing activities. These are the things that you can do as a consultant, and that only works if you do not want to engage in full time practice, because if you are engaged in full time litigation, most of your time will be spent in court. Not everybody likes to do that. So if you are a consultant, a lot of time, most of your time will be spent in office working on these kind of matters.
Sure sir. Thank you so much sir.
Thank you.
Thank you sir.
Thank you, Mr. Amrit. Could you please share your LinkedIn link and mail ID in the chat box so that if any questions are there, they
If,
can post
sir, I
it.
would like to request you to drop
In
your
the chat box.
Only my email ID.
so you can post
LinkedIn
your
link
LinkedIn
as well,
also.
if you're okay with it.
Right, just give me a minute, let me share it with you.
Shrishti, you can take over.
Yeah. Moving ahead, we would like to express our sincere gratitude to Mr. Amrit, Assistant Professor at United World School, School of Law, Karnavati University, for being our guest today at Conversation with Consultants. Your presence and engagement has helped it to make it a success. Thank you, Mr. Amrit.
Thank you, Shrishti, and thank you to the organizers of SK Associates and Group. It was wonderful interacting with all of you, sharing my insights, and I hope to remain in touch. And it was lovely to share my thoughts with you.
Thank you so much, sir.
Thank you. I'm just
E-
sharing my
e-
details in the chat.
Good morning, all of you. Amrit, this
sure,
side,
sure.
Dr. Devendra Kokar. Would you
Yes,
like
yes,
to share your number so that we can discuss one to one with you on some particular issue related to medical industry?
sure, sir. I'm just sharing my number in the chat also. I've shared my LinkedIn ID and my email ID. I'm sharing my contact details in the chat.
After this meeting, I will discuss with you. Thank you.
All right. Yes, so I've shared my email, my LinkedIn, and my contact details in the chat.
Thank you so much.
Okay,
So even I
thank you.
would like to thank Mr. Amrit for his participation as a guest speaker at our event. Thank you for providing insight into your inspirational journey. Further, we would also like to thank our audience for listening patiently throughout the event. Thank you everyone for joining with us today.
Looking ahead, we are excited to announce that our next episode of Conversation with Consultants will be held next weekend. We hope to see you all there. Thank you again, and we look forward to reconnecting with you next week. Do subscribe to our YouTube channel and follow us on all social medias. Goodbye and have a great day ahead.